For the earlier order of this Honorable Court, the matter
No,
regarding
no, no.
regulation of
Sorry,
service-
sir. Sorry, 1 minute, sir. We have to pronounce a judgment, if you don't mind.
Sorry, this matter is Justice Kerala.
Oh, I see. All right. Yes, sir. Continue.
Yes, ma'am. Well, the matter regarding regularization of service of a casual worker and his direction was given to regularize service, considering him to be engaged in a vacant post, and according direction was given. But fact remains that he was never appointed against a vacant post, and no process of selection he has also faced. That the two things court has not taken into consideration while passing the interim order minutes. But I pray this. These
Sir,
things
the
are-
order was passed on 7th March 2019.
my lord, thereafter what happened? By mistake, the authorities of the concerned authorities, they thought that they have to consider the matter on its own merit and to pass the order accordingly. Accordingly, they have passed an order on the ground that because of these two reasons, service cannot be regularized. Thereafter, again, application was filed. Thereafter, we thought it proper to file a review application for review of this order.
No, 700 days is too much.
And we considered his matter after the judgment, but that was not the direction. Therefore, we have again filed an application for review of the order on this ground.
Casual, sir, look at your condonation bail application. It's
Yes,
too bad.
because of that reason, there has been some delay.
No, not some delay. It's 2 years delay.
That is the reason. That is the reason.
All right. No, we'll dismiss it on delay, sir. You say the delay.
Delay because of this reason, because we have considered in time, but we have considered thinking it that the order is to be complied with by considering his grievance.
What?
Consider his grievance.
There is a delay of over 700 days in filing this review petition. The explanation offered for the delay in this application is wholly unsatisfactory and not convincing. Consequently, this court is not persuaded to condone the delay. The application is dismissed. And the main matter, you say, since the delay application has been, the condoned delay application has been dismissed, the review petition is also dismissed.
My lord, 2 other cases are pending with your lordship, identical matters. At a time, those 3 cases were disposed of. If your lordship permits me, can I give the number? Same thing, same, everything same.
No, review petition number.
Yes, my lord. If your lordship permits. If your lordship
filed by
permits.
Mr. Swine.
No, he has filed Mr. Das.
I am Bimbisar Das.
Bimbisar
No.
Das has filed.
Who has filed those review petitions?
Union of India.
Union of India.
A common order, review 3
Common
petitions were there. A common order, 3 review applications has been filed against 3 writ applications.
No. So you must only filed the review petition, or who filed it?
No, Mr. Bimbisar Das has filed. One I have filed. Another.
So unless he is present, the only problem is whether.
102 of 21, my lord.
Sorry.
102 of 21 also. I mean, out of
No,
same
no.
order, I have also filed.
Unless the council who filed them is present, sir, we can't simply take it on board and dismiss it. You give us the numbers. We'll have it listed on another day.
Yes, my lord. 64 of 2021. 64 of 2021. The other one is 102 of 2021.
All right. Okay. We'll list it on next Friday or whatever, sir. All right.
Yes.
Thank you, Justice Mahapat.
For delivery of orders,
Yes.
CRLA number 210 of 11.
This appeal is separated from the other connected batch of appeals and be listed before appropriate single bench, keeping in view that the conviction is under section 25 of the Arms Act and the appellant has been sentenced to undergo RI for 5 years.
Item number 2 for judgment, CRLA number 288 of 11 and other batch of cases.
Resultantly, the conviction and sentences are as directed by the London Trial Court in respect of the appellants are set aside. All the appellants are acquitted from the charges and they be set at liberty forthwith if their detention is not required in any other case.
I agree.
For orders item number 1.
What?
Item number 1, CMAPL 368 of 2021.
May I please,
Yes.
Your Lordship?
Yes, sir.
This is for restoration of order dated 14/9/2021, my lords, passed in WPC number 16021 of 2021, my lords. The present application was dismissed for non-prosecution, my lord. In the
What
meantime,
is
my
there the
learned
main
senior-
matter, sir? Tell us about the main matter.
Main matter. The application has been filed challenging the judgment passed by the learned tribunal, my lords. One second.
What does the tribunal do?
In directing the petitioner to reinstate opposite party number 2, my lords, in his service, my lords. I'm praying for quashing on the ground of res
So what is wrong in giving him one more chance? Let's look at issue number 2.
My lords, opposite party number 2, the private opposite party are appearing, my lords. The counsel for the private opposite party. They need to explain, my lords. Let
No,
it be
you're
restored, my lords.
appearing for whom, Mr. Monty?
Ganon Dockley, my lords.
No, who has filed the CMAPL?
I have filed, my lords.
So you please come to the main award.
Yes, my lords.
Only direction is you should reinstate the workman by giving him another chance. What is wrong with this?
My lord, actually, I do not have the main read, my lord. Actually, I just the consent right now. On the previous read, and my senior, learned senior, was appearing, learned Shiv Shankar Mohanty.
This check has been deposited.
My lords, I
There was an
actually do
order
not have the
asking you to
read file,
deposit
my
an
lord.
amount. All right, it's asked to be disbursed. Who's appearing for the workman?
Private opposite party, my lords.
No. Who's
Neither,
appearing for him, sir? See, one Mr. A. Jena appeared.
A.
Mr.
Jena.
Satyamanti was used to appear.
So whatever the names we are given is A. Jena and M. Badu. So you serve advance copies on them. Otherwise, it will only get delayed.
Yes, my lords.
Copies of the present application be served on Mr. A. Jena, shown to be appearing for opposite party number 2, and Mr. M. Badu, learned counsel, shown to be appearing for Union of India.
My lord, I am appearing for the Union of India, my lord.
All right, just say he appears for Union of India. Copy of the present petition be served on Mr. A. Jena, shown in the order dated 14th September 2021 to be appearing for the opposite party number 2 workman. List on 18th February.
Item number 2.
May it please your lordships. But this is a very unfortunate case. Lordship, the conducting counsel, Sri Damodar Pati, died in the month of August. And
So the original writ petition challenges the assessment reassessment order.
assessment that is covered by your lordship order that before you, unless there is an assessment under section 39, 42 and 43.
Keshav Automobiles.
Yes, madam. STRB number 64.
Mr. Padi, is that right? Keshav Automobiles.
My lord, here I just want to point out one thing, my lord. One distinct feature is at page 77. By a specific order, the returns have been scrutinized and has been accepted. So that's the distinguishing feature here.
No, but unless there is an original assessment, you can't have a reassessment. Sir.
My lord, the original, this is the self 39 assessment. That's a specific order has been passed. My lord, may kindly see page 77. The returns have been scrutinized and no irregularity is found, hence accepted for the period from so and so. So here 39 self-assessment speaking order has been passed.
Oh.
The distinguishing feature. So
Lordship, may kindly see.
hence 43 is bad is not applicable.
Just a minute, Mr. Padi, wait. Kindly wait. Please. Kindly see my lord's annexure 15 at page 75.
Yes.
This reassessment was initiated at the behest of the higher authority. Lordship will kindly see letter number so and so from dated 21/8/2010, along with inquiry report of case of Hotel Raj Mandir, Balangir, submitted by the SCCT Balangir Circle, Balangir on dated 17/8/2010 to the tax period 1/4/2005 on 2/28/5/2010 may be seen, wherein the JCCT has directed to complete the assessment under section 43, my lords. The opinion has to be formed by the assessing officer himself. He cannot act at the behest of the higher authority.
So this is a different point. So this is not the Keshav Automobiles point, it's a different point.
Yes, ma'am.
So what do you say to that, Mr.
Taken
Kadu?
two.
No, so
Yes.
what do you say to that?
My lord, here the inquiry report has been forwarded and
No.
use the word directed, but he
This
should
is
have
a
recommended.
direction from a superior to the AO saying you better do it now.
My lord, but that, my lord, in my humble submission, would not vitiate the proceeding itself.
Of course it will. What are you saying? Of course it will. The opinion has to be formed by the AO. It can't be at the behest of the superior.
Yes.
All right. And you say for the reason stated, the application is allowed. Writ petition is restored to file. In the writ petition, you say one of the principal grounds of challenge to the impugned reassessment order is that it was done at the behest of the JCCT and not the assessing officer. Paragraph, having heard learned counsel of the parties, the court notes that in the remarks against the order dated 10th August 2010, it has been stated by the sales tax officer as under. Then reproduce the third column, page
That
75.
letter is at page 57 also. That letter of the JCCT is page 57.
Yes. The above letter indeed issues a direction to the assessing officer to complete the reassessment for the reasons stated above. This is a classic textbook case of the AO acting under dictation of a superior officer, which therefore vitiates the entire proceedings under section 43 of the Orissa Sales Tax Act, 1947. Paragraph, consequently, the impugned reassessment order is hereby set aside. The writ petition is allowed. No orders is to cause.
Obliged, ma'am.
All right.
Deeply obliged.
All right. Right.
Deeply obliged.
Right. Good morning, Justice Mop.
For judgment, WPC 7012 of 2014.
In view of the facts and circumstances narrated herein above, the present writ petition has been disposed of in the light of the orders dated 23rd July 2005 and 13th September 2005, subject to further clarification that the petitioner shall be considered for contractual stopgap and ad hoc appointment in the office of the opposite party, subject to the petitioner fulfilling the eligibility criteria fixed by the authorities in any specific project work in future. With the aforesaid observation, the petition shall dispose of. So no order has to pass.
All right. I agree.
Run.
Mr. Rao.
Lords, earlier this case was one Mr. M.K. Gupta was the arbitrator.
I know, he's declined, sir.
Now Mr. Srivastava was appointed on his death, and this Srivastava has also declined. So Lords, may I appoint some advocate, my lord?
All right. Look, what's the claim amount?
Claim amount is the agreement amount was around 28 lakhs.
What about Shashwat Acharya? He's a young advocate, but
yes.
All right, Mr. Shashwat Acharya, advocate, he is appointed as an arbitrator to adjudicate.
Yes, he's a very sincere and good boy, man.
That's it. I hope he's not listening. All right.
For admission item number 2.
Other terms will remain same, my lord.
Yes,
Because-
yes.
Lordship, in this matter, Lordship, I am appearing on behalf of Railway Administration. In this matter, Lordship previously appointed retired chief engineer.
No,
This
it's
our
all
court
right.
approved.
It's all right. Let the advocate be substitute by advocate only. All right.
For admission item number 2.
May I please? This is an application for appointment of arbitrator. Section 11 application of all the opposite parties have already entered appearance and they have filed their respective counters. I have also filed the rejoinder. Your Lordship, kindly have a glance to agreement. There is an arbitration clause, my
Yes.
Lordship, kindly have a glance to page 39. Clause.
No notice has been issued yet.
Yes, notice has already been issued.
For 1, 4 and 5, my lord.
You are 1, 4 and 5.
My lord.
Why so many?
Mr. Bhuya is appearing for all other opposite parties, my lord. And
Mr. Bhuya, you are there?
HS Dev, my lord.
No, so what is the objection to appointment of an arbitrator? Tell us.
My lord, kindly come to my counter page 5, my lord. Running
Yes.
page 5.
Right.
My lord.
Where is counter? Read, please.
That apart, from the top, my lord. That apart, the opposite party number 2 to confirm the terms and condition of deed of agreement dated 17/9/2010 has filed CS number 16/12, my lord, in the court of the Civil Judge Senior Division, Jaipur, which is now pending for disposal, my lord.
No, that is not, my lordship. Kindly have a glance to the suit of the year 2015. In suit, they have agreed for appointment of arbitrator.
No, but why have you filed another suit then?
No, this suit is not related to that. This hotel.
No, have you filed a rejoinder? Have you filed a rejoinder?
Yes, I have filed rejoinder. I have did.
Sir, when did you file rejoinder? It does not come on record.
Yes, that is on record, my lord. Noting is that rejoinder is there.
1 minute, let me just see. Rejoinder is there, correct. Not scanned.
Bookmark.
About the CS, my lord, totally silent, my lord.
No, regarding the CS of 16, what have we said in the rejoinder?
That is a CS of 2012. That is CS of 2012, not related to this hotel. I have stated, my lordship, they have agreed for appointment of arbitrator. Learned court below also.
Which para of the rejoinder you say it's not related to this?
Not mentioned, my lord.
Yes. Paragraph number 6, my lord, that the documents which are filed by the opposite party in their counter affidavit have no nexus to the present arbitration application since they are executed and filed in the year 2010 and 12 prior to partnership and the civil suit number 34/2005. In civil suit, they have agreed and civil court also directed both the parties for appointment of arbitrator. They have filed application for appointment of arbitrator before the civil court. Section 8 application.
No, it's a decree passed in 16 of 2012, sir.
Decree.
You should give a proper reply. Your reply is very sketchy. You're only saying documents have no bearing. What does that mean? Just look at the averment in para 9 of the counter affidavit. It's such a detailed averment, and you've just in one line simply said A4 and B4 have no relevance. That is not good enough, sir.
Hey, Lordship, just for a moment, kindly have a glance to their return statement, my lord, before the civil.
I'm having that only.
And read application, that original application, arbitration application, page 43, my lord. Section 11 application, page 43, my lord. That is their WS. Page 42 and 43.
So they have taken the objection on maintainability of the suit.
They have filed an application and 43 towards 4-5 lines at any rate since the plaintiff has come up claiming to be a partner as per the deed of partnership dated so and so, she is bound by the terms and conditions there of clause 11D of the partnership. It contains an arbitration clause. It mandates that any misunderstanding dispute among the partners.
Yes, Mr. Dev. Yes, what do you say to this?
And your lordship kindly have a glance to page 48, order of the civil court.
Suit is pending, my lord.
No, suit has been disposed of. Your lordship kindly have a glance to
That's
page
right.
48.
Yes,
Page 48, your lordship. Last
That is-
paragraph, page 48.
Confirm the terms and condition of the deed, my lord, which
That's
is
right.
pending, filed by OP number 2.
It's okay, sir. Now the arbitrator can decide all other points.
Yes.
What is the extent of the claim?
External is a partnership for my lord. Partnership are regarding a hotel business, my lord.
We appoint Mr. S.S. Rao. Is that all right?
My lord, I have no objection.
All right. Having heard learned counsel of the parties and having perused the pleadings, the court reserves the right of all the parties to urge the respective contentions as regards the claims and counterclaims before the learned arbitrator in accordance with law, and proceeds to appoint Mr. S.S. Rao, senior advocate, as arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the High Court Arbitration Center.
Oblige, man. Highly obliged.
Item number 3.
Item number 3, my lord. Application for appointment of arbitrator. I have my friend has filed their counter, so also I have filed my rejoinder.
Yes. What's the objection? Who is appearing for the opposite party?
My lord, the objection they have raised.
No, let her say. Let her say. Yes, Miss Benny.
Bless your lordship. Like the first objection that we have is this agreement cannot be acted upon as it is not only unregistered, but also it is unstamped, your lordship. Your lordship, according to the decision of the Supreme Court in SMS states Vijay Drolia and including Coastal Marines, this agreement cannot be acted upon, your lordship, and it is liable to be impounded, your lordship. It is only
Yes,
a
sir.
mere notarized agreement.
Yes, Mr. Mishra, what do you say to that?
My lord, my answer that both the judgments has been declared as not good law. In case of my lord NN Global Mercantile versus Indo Unique Claim Limited.
Where is the judgment? Where is that judgment? Where is the copy of the judgment?
Your lordship, if I may be allowed to submit, your lordship.
So lordship may permit me in the next week I'll file a compilation of their judgments. It is reported in 2021 volume 4 SEC page 379.
Yes, Ms. Mishra.
At paragraph 57, 56.
All right, let's hear Ms. Binny Mishra. Yes.
Your lordship, I also may be permitted to submit the judgments on my favor. However, I may bring it to the notice of the court that both are judgments of 3 benches, and NN Mercantile has been referred to a larger bench also in the meanwhile.
Yes.
So then it has to await the larger bench.
SMS T, my lord, for a moment. SMS T State and Garwal Quail case has been declared as not correct position in law.
No. So this itself has got referred to a larger bench.
Yes, it has been referred to larger bench. Has been
You
referred
say
to
one of the main
Mercantile.
objections. Yeah, all right. One of the main objections raised by the opposite parties to the maintainability of the present petition is that the agreement containing the arbitration clause is not properly stamped and is also not a registered document.
Yes.
Paragraph, it appears that this very issue is now before a larger bench of the Supreme Court of India.
My lord.
Full stop. Awaiting the outcome of the said judgment. This petition is adjourned to 6th May.
Yes.
Deeply obliged, your lordship. Deeply
All right.
obliged.
Well, it was referred to larger bench on 11th January 2021.
All right.
Item number 4.
Clause 4, I am appearing and for the petitioner, and for the opposite party also, learned counsel Mr. Dwivedi has already appeared and we have served the copy.
Yes, Mr. Dwivedi.
Lordship, there is one problem. There is no invocation letter in the petition. Actually, I am the claimant. I have invoked. I have submitted
all the better then.
Yes, but the problem is there is already an appointment has been made, and that appointment is as of now continuing. And I have challenged that appointment before the section 14, before the learned district judge Khorda. And
So all that can come to an end. You just agree on the name of an arbitrator now. Another arbitrator.
But Lordship, that may be just one thing, maybe no. Just maybe mention that I'll be allowed to submit my claim as the claimant, because they have filed the application and the tribunal will send them notice as claimant. So that maybe there maybe has to be a juxtaposition of the parties.
It's all right. One will be the claimant, other will be the counter claimant.
Yes, but that is the only problem that may be mentioned in the order. And Lordship, I suggest the name of Justice Mr. A.K. Mishra, Justice A.K. Mishra, or Mr. Justice Pramod Patnaik. Anyone, Lordship. It's a claim and counterclaim is somewhere around 5.5 crore. My claim is 5.5 crore. They have not submitted any counterclaim as of now.
I think Justice Pramod Patnaik.
My lords. Justice Pramod. Yes, my lord.
With the consent of both parties, Justice Pramod Patnaik is appointed as sole arbitrator to adjudicate the disputes between the parties, which includes the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. Then you say the pending proceedings involving the issue of appointment of an arbitrator will abide by this order and can be full stop. Accordingly, the present order will be brought to the notice of the forum in which the other proceedings are pending. Right.
My lord.
The petition is disposed of.
Item number 5.
Item 5, my lord. So in this case, we have filed the rejoinder yesterday by way of e-filing, and a copy has been served on the Advocate General's mail ID, and we will serve it in the counter if they may please. And the next week it may be set for final hearing.
All right. Rejoinders stated have been filed, we brought on record. List for hearing. 25th February. Not 25th, sorry. On 18th February, sir.
Deeply obliged, sir.
Item number 6.
May it please this honorable court. I am appearing for the claimant petitioner in this matter.
Yes.
Let's.
Rejoinder not received anyway. Who's for the opposite party?
Yes, I am for the opposite party, my lord. I place a certain adjournment, my lord, because I have not gone through the file, my lord, because from illness after my recovery, I have not gone through.
All right. At the request of Mr. Sishir Mansi, learned counsel for the opposite party. List on 8th March, sir.
Obliged, my lord. Deeply obliged, my lord.
All right. 8th March. Yeah, Friday. That's a holiday. What Friday?